Okay, that makes 2 times in a row I forgot to plug my microphone in, so hopefully this one works now. Any sound now, Factual? Okay, cool. All right, so let's start with a look at the charges in this case. There we go. All right. Hold on 1 second. Okay. So we're going to start by looking at Fulton Jail. Oh yeah, so this is just going to be a rant about Fulton County. I don't know where this is going to take us. It's going to start with Lil Rudy, but it could go anywhere. It could go back to the 90s. It could go... I have no idea where this is going to take us. This is just going to be stream of consciousness. I mean, it usually is, but, you know, even more so than usual. Okay. Can you guys see this reasonably okay? Probably not, because it's really small. Let me get my own channel open so I can see what you guys are seeing, more so than usual. It looks reasonably okay. Hey everybody, Trakisha. Kat says hi. I'm supposed to tell you that. Let me get my own channel open so I can see what you guys are seeing, more so than usual. It looks reasonably okay. Am I loud enough? It seems like I'm not on my end for what I'm listening to. Hey everybody, Trakisha. Okay. Actually, no. Before I start that, I want to show you guys something really dumb. This is completely unrelated to everything, but we're just gonna... That's what we're doing today. Hey Vanessa, appreciate it. Appreciate the like. A thing I'm supposed to ask for. So this is what they think Unfunk's name is. Jeffrey Williams, aka Young Thug's brother. Quantavia. It's not, but that's what they think his name is. Is it this one? No. Let's go back to this one. Here we go. This is simply the dumbest AKA. They have a lot of dumb AKAs. Let me zoom in so you can see this. You have to select everything to see the text. But here is Quantavious Greer, alias Quantavious Greer, which is not and also no, it's just the same name a second time. But then it says AKA Jeffrey Williams. And you may know that Jeffrey Williams is not well, nobody's Quantavious Greer. But to the extent that anybody is Quantavious Greer, that person is not also Young Thug. So they actually have Young Thug's brother as an AKA for Young Thug, or Young Thug is an AKA for his own brother. So that's a bad start. But that's not what we're here for. That's not what we're here for. Sorry, that was apropos of nothing. Okay, new search. This is what we're here for. I'm not gonna get sidetracked. Yes, I am. I will get sidetracked like that again. Here we go. So it looks like Kenneth Copeland has already been released from Fulton anyway. Let's see here. Zoom out a little bit. I don't know why they're going to do my man like this. But let's see. Let's go through these. We have reckless stunt driving misdemeanor, driving in circular or zigzag course, which, as you'll see here, is also a misdemeanor. What else do we have? Driving on wrong side of road. That sounds bad. I probably should have put in Georgia. Or Georgia. Let's see. 40. This is a misdemeanor. I know this is. I know that this is. Yes, every one of these is a misdemeanor. I gotta say, a $10,000 bond for a misdemeanor is quite excessive. But that's not even what we're here for. Let's go to... He did self... he does drive pretty crazy, don't get me wrong. He probably even deserves, you know, some kind of charge. I don't know that he does for certain, but it wouldn't shock me. But this is the Gwinnett County case that he has. I'm pulling it up now so I can share it to you. There we go. So we have... That's fine. It's a different Kenneth Copeland. 1971. Anyway, this is his new case in Gwinnett County. And you'll see that this is also a misdemeanor. So he has something like $20-something thousand in bond purely for misdemeanors. And who is it? Factual Lie, who said that he self-snitches? That's correct. he does self-snitch quite frequently. $1,000, $627. But you know, I have something way dumber. I have something better. But I guess I should put a cap on all that and just say on that, not in that. Yeah. And just point out that all of this stuff is misdemeanors, but despite that, he has 10, 15, 16, 17, 18, 19, $20,600 in bond. Plus another, what is that? $1,185, I think, in court fees. Yeah, that's right. $1,185 in court fees. And the misdemeanor charge, the Fulton County charge is also a misdemeanor. One thing that's interesting is that there's no obstruction charge here. And Fulton County will charge you with obstruction anytime you resist in any way. If you try to get away, if there's a chase, they will always charge you with obstruction. The fact that I don't see that here tells me that he just got pulled over without incident. I'm quite confident that that's the case. So for all of these to be piled on here like this, despite the fact that it was apparently an arrest without incident, is telling to me at least. What else do I want to show while I'm on this page? I'm just taking a guess that there's something in here that could be funny. Let me zoom in just in case. Oh, that doesn't work. The fuck is Antonio? And then you click on it, and it's somebody named Napoleon Matthews. Who the fuck is that? I typed in Antonio Sledge. I get Antonio Sledge. Then I click on Antonio Sledge, and I get somebody named Napoleon Matthews. The fuck is that? Who the fuck is Napoleon Matthews? That's a sick name. That's an A+ name. Don't get me wrong. I'd love to meet Napoleon Matthews. No disrespect to Napoleon Matthews. There's no Napoleon Matthews slander here. But what the fuck is this? And I'm 100% sure that this was a different name the last time I looked at it. I was totally expecting a different name to pop up there. I'm not even kidding. It was Perry Sledge last time I looked. Did they change it? The fuck is this? Did they fix it? Well, I mean, they didn't fix it, clearly. Okay. Oh, this is I know who this is. I know who this is. This is... Never mind. I can't tell you that. But I did just discover something. Joseph Papp posted the Gwinnett warrant. Let's see here. Ah! All right, let me switch over to that tab. Let's see if you can see that. Yeah, let's read through this real quick. They Fulton fixed it. All right, how do I think I'll do this on screen share, actually. You can disregard that I'm about to open this in Paint. Don't worry about that. Here we go. So this is the warrant for the Gwinnett County arrest. Actually, let me just check and see if they have the right number on this. Is this 622? Wait a minute. Is that the right date? I think it is. $25,121. Okay, yeah, this is the right warrant number. All right, can you guys see this okay? I think you can, more or less. Okay, who do we have? Judge William Brogdon. That name rings a bell, but I can't remember why. Let's see. Kenneth Copeland. Personally appeared the undersigned prosecutor, M. Jewell. Gonna Google the Apex unit, M. Jewell, real quick. Not Richard Jewell. Can't find him yet. I'll have to look for him later. Let's see. Undersigned Prosecutor M. Jewell, who on oath says that to the best of the prosecutor's knowledge and belief, the above named accused between 6:22 p.m. and 4:10 at Cruz Road, apropos, Lawrenceville, Georgia, Gwinnett County, did commit the offense of actively facilitating an exhibition of illegal drag racing or laying drags misdemeanor in violation of 161143.1b and against state of Georgia and the laws of the state of Georgia. The facts of this affidavit for arrest are based on defendant was knowingly present while actively participating in and helping facilitate the exhibition of illegal laying drags by throwing water balloons. You set me up for this, Cat, didn't you? That's why you put this. That's why you linked this. You wanted me to be mad. Oh God, I can't believe you got. Okay, is this fake? This is fake. Is this fake? Defendant was knowingly present while actively participating in and helping facilitate the exhibition of illegal laying drags by throwing water balloons and hanging out of the sunroof of a car laying drags in the intersection. What the fuck does that mean? In an intersection takeover themed Wet and Wild, an event where bystanders were seen throwing water into the intersection through various means to fulfill the theme. If you're a bystander for throwing water into the intersection, and Rudy is throwing water into the intersection as well, how is he not also a bystander? What makes the other water throwers bystanders, but Rudy not a bystander? A. B, most importantly, you're gonna sign your name to this? Bonnie Willis is out here talking about a mother getting executed in front of a 2-year-old child, and you're going to sign a fucking police affidavit about water balloons. Now, granted, that's Gwinnett County, not Fulton County, but I think it's enough of an overlap to be concerned. Throwing water balloons. Did he make it rain out the top of the drop? Is that what Shannon meant all along? Just raining the water balloons down into the middle of, what was it, Cruz and Oakland? I'm going to close my window. I don't want to hear people hear me yelling about God knows what. That's going to be the most expensive water balloon. True. Order for bond. It is hereby ordered that the aforesaid accused, Kenneth Xavier Copeland, be and is hereby granted bail to be made with sufficient surety as approved by the Sheriff of Gwinnett County in the amount of $1,000 to assure the presence of said accused at arraignment, trial, and final disposition in the Superior Court/State Court of Gwinnett County. This is going to be one of those days. I guess I got to read this again. This is fucking fantastic. The facts of this affidavit for arrest are based on defendant was knowingly present. No, it wasn't an accident. He wasn't just, throwing some water balloons innocently out of a car and then a fucking intersection just spontaneously was constructed in front of him without his knowledge. He knowingly threw water balloons while hanging out of the sunroof of a car. And how do you lay drags while hanging out of the sunroof of a fucking car? What does that even mean? I don't even know what that means. Laying drags? Defendant was knowingly present while actively participating in and helping facilitate the exhibition of illegal laying... No, this is even dumber. Helping facilitate the exhibition of illegal laying drags... Laying drags in the intersection. It's circular, too. Much like a water balloon. It's also circular. Okay, I gotta start again. Defendant was knowingly present while actively participating in and helping facilitate the exhibition of illegal laying drags by throwing water balloons and hanging out of the sunroof of a car laying drags in the intersection. In an intersection takeover named Wet and Wild, or themed Wet and Wild. An event where bystanders were seen throwing. How do you throw water? How do you throw water? You can't just, like, throw fucking. Okay. Like water bottles? An event where bystanders were seen throwing water into the intersection through various means. I get it. I'm sorry. They were specific there. But through various means. To fulfill the theme. A question. Was he, by throwing water balloons and hanging out of the sunroof of a car laying drags? So, are those separate things? Or was the throwing of the water balloons part and parcel of laying drags? This is so much better than I expected. This is so much better. I knew it was dumb, but I thought it was like, normal dumb. This is special dumb. It's like Gwinnett County was jealous of the love or hate that Fulton County was getting, and they're like, no, we can't allow this to go unmatched. We need to top them. And then they write this shit about water balloons. But more importantly, how is this young thug's fault? I think that's the real question here. Okay, let's get into something else that's stupid. Whoa! Speaking of circular, let's look at my favorite stupid motion of all time. That's a strong statement, but it's one of the stupidest motions of all time. This is from 2020. You'll see here, Kenneth. Ooh, make that bigger. Slide that over a little bit. There we go. People are hot. They were doing antipathy is correct. All right. So here we go. State's motion and memorandum of law in support of admission of gang-related evidence at trial. This is a 2020 case. You see here. Highlight. I'm going to fucking lose it. Okay. So, I don't know why they formatted it like this. Comes now the state of Georgia, blah, blah, blah. The state's motion and memorandum of law in support of admission of gang-related evidence at trial. This is just the worst font I've ever seen. The defendants in the above case have been charged inter alia with violations of the Georgia Street Gang Terrorism and Prevention Act. You've probably seen this 8,000 times. Basic facts of the case. And this is real, by the way. This was filed. So you guys can see this really well. Optional section. Consider inserting police reports, statement, proffers from gang members / associates, in this or other cases and or secondary sources on gangs in general or the gang in the case at bar. This is a default section that they never even bothered to correct and to complete. Hey, David. Ashley, is he on probation? I'm not sure, actually. I would guess he is, but I can't say for sure. I have another fun thing about this particular case, this particular motion, but I want to find a more recent version to show you that I'm not lying about this particular issue. Or I guess you just take my word for it, but if we need to, that'll be fine. Make sure I don't show anything I'm not supposed to either. I guess we just use this one. That's fine. Okay. So I was suspicious of this motion because I've seen it so many times and it's never updated. So a couple, maybe months ago, maybe like 2 months ago, I decided to go through every single citation and I found some fun ones. Let's see, the one I'm looking for, I can just Control F it. This guy. So, this is unchanged. It's 2025. This version is from 2020, but it's the same in 2025. And, oh, well, this switched to my browser, so I'll have to show you. But it is a 404. That is a broken link. Then the next one below that is it's an insecure PDF. And then the next one below that, I think the next one works. It does not. The next one also does not work. So it's full of broken links, first of all. I think you can check the unsecure PDF if you want to. But I was curious about this particular one right here. It's by, this is actually not his name. It's actually LUD. Oh, I didn't show you. Let me switch back to the PDF. I was curious about this one because it's a California. I recognize this citation. This is one of the California Law School's law reviews. It's Cal Western. I don't know what that is. But hey, Angelico. But I was curious, so I looked up this law review note and I read it, and I have it here for you. Let me just download it real quick. Here we go. And so you got to remember that this specific law review note, also, first of all, they got his name wrong, but in any event, I was curious what this had to say. This article had to say. What Brian here had to say. Yeah, he went to Loyola, apparently. That's kind of like a real law school. And we're not going to go through the whole thing. But his conclusion says, with the existing prevalence of gangs and gang violence, it's likely that gangs will be a part of American life for many years to come. The above criticism solutions may not have any immediate appreciable impact. However, society must begin to rectify the current situation by addressing the criminal justice system's shortcomings in fighting gang violence. First, society must remove its focus from stereotypical factors thought to cause youth to join gangs and identify the factors that actually cause youth to join gangs. In particular, society should attempt to alleviate the problems created by at-risk use of adequate family support, the missing protector factor. Second, the criminal justice system must ensure that its war on gangs focus neither primarily nor unfairly on minorities, and that it does not have the appearance of doing so. Law enforcement officials must ensure that this war is waged not only on poor minority urban gangs, but also on affluent white suburban gangs. Failure to apply enforcement solutions uniformly across racial and economic boundaries will assure the criminal justice system and society in general of failure in the goal of stopping gang violence. And so, I thought that doesn't really sound like something that would support Fulton County very much. So I actually emailed this guy, because he works down the street from me, And, oh, woof, woof, woof. Let me see if I can get his exact words. Let's see, what did he have to say? He said, "Thanks, Jim. It's been ages since I wrote that. I feel like it doesn't really support the point for which it is cited. My point was that if you're going to have gang enhancement laws, you have to enforce them consistently." So, I kind of fact-checked them on that one, and they're wrong. Let's see. I also checked this one, and this one, and this one. And you'll see here, this is from 1998, 2005, 2007. So all these are nearly 20 years old at this point. And irrelevant. So, yeah, that's pretty dumb. Okay. Next, we're going to pivot here. We're going to talk about lyrics for a second. No, we're not. I changed my mind. I have something better. We're going to talk about one of my favorite topics. This is something called the Georgia Gang Investigators Association. Where did I put you? Here you are. I was looking for you. Hey there, always. So this is going to be a Dober hearing transcript. Once I switch to PDF. Yep, you should be able to see it now. A little bigger. This is the Marissa Viverito Dober hearing transcript. So now we're talking about the Georgia Gang Investigators Association, who definitely does not dox their own members. Okay, what training and education have you had in the field of gang identification and gang investigations? She talks about some actual training. And she says, I've also had the basic and intermediate certifications from the Georgia Gang Investigators Association, as well as a class on advanced gang investigations, gang interviewing. I attend the GGIA conference. Usually I try and go twice a year if I can, whether it be the winter conference and the summer conference if our budget allows. And those are weeks long. Or the winter one is a little shorter, but the summer one is like a week-long worth of training, just all on gangs with people from different states from Georgia. It's a good bit of diverse training. Blah, blah, blah. Okay. What trainings have you given to other investigators? I'm actually part of the instructor cadre for the GGIA, so I do a training on social media identification and investigative techniques and advanced techniques in gang cases. Do you know the number of classes that you've taught? I typically teach at the summer conference, so I probably would say maybe 4 of those, and then it just depends. Different organizations or agencies, like in the next week or 2, I'll be teaching down for Georgia Department of Corrections, so I'll say maybe 10 or 15 times at least. Have you developed any trainings or courses? Yes, the course I teach was developed. I was asked to come and teach, and I created it from scratch. You created the course that you taught. I did. And what did you use to develop this course that you developed? I use cases that I've investigated, my techniques and methods for doing investigations, as well as I have spoken with other investigators that I deemed to be extremely knowledgeable, and other instructors, and basically the other instructor cadre at GGIA when developing my course. Jumping forward. And are you involved in any gang investigator associations? I'm a member, and as I said, part of the instructor cadre of the GGIA. I don't know more about that. Have you been certified through GGIA? It says, I have. In which areas, both basic and intermediate. Talks about an award she won from the GGIA. Who did you develop the courses with that you dubbed for GGIA? It was myself. Hey, Aaron. Then these are the various mentions of the GGIA in her resume. That's not highlighted for any particular reason. Definitely not going to say that. Yeah, that's right. This is a Dobert hearing transcript. And my point I was making is just that the GGIA is prominently and repeatedly mentioned in her qualifying as an expert under the Dobert/Kumho Tire standard. And so we're going to take a look at how deeply serious of an organization the Georgia Gang Investigators Association is. I think that would be a good use of our time. So this is the first one. Actually, I want to start with one other one first. Let's see here. Go back up here. Here we go. Let's just delete all these. Let's get a little slimier with this, actually. There we go. I like that. So, the summer one is a week long. It's 4 days long. The winter one is slightly less than a week long. It's slightly less than a week long. Slightly less. Slightly less than a week long. So let me count, make sure I get this right. So it's 11, 12, 13, 14. And then this is 4 days. The 11th is a 5th day. And then the 12th is a 6th day. Now, I'm not an expert, but I think a week is 7 days. So if you compare this, it says, those are weeks long. We're going to make these red for the color of the fire on her pants. Sorry for that abstract art there. So she's lying. How many episodes of Sons of Anarchy can you watch in 2 days? Correct. So, this is the very serious 2017 flyer. A little bigger. Survival in the streets and in the courtroom. Kinky. It is at the Savannah DeSoto. Human trafficking, and I don't know why this is capitalized. That's weird. Gangster Disciples Street Gangs, yesterday and today. I really love that they put this in quotations. But yeah, this is the registration form. Gaither about that one. Okay, let's see. I want to show you the agenda that I found from 2020. Here we go. These are not really public, but they're not very good at security. Here we go. Hopefully you can see that kind of okay. 2020 GGIA Winter Training Agenda. Sunday, we have a check-in or registration, more registration. We have an invocation from GGIA. Hey, we got us introductions from GGIA. Gang Case Study, Young Slime Life by Mark Belknap. And J.P. Miller from something called Cherokee County. I'm going to look that up because I have no idea where that is. That looks like it's a bit north of Atlanta. North of Alpharetta, northwest of Alpharetta. I'm just going to show you that real quick. So the YSL is supposed to be, supposedly, southeast Atlanta. Let's see if I can show you my mouse real quick. Oh, it doesn't work. Anyway. Yeah, so YSL is supposed to be like southeast Atlanta, down by like the 285 sign is. And completely in the opposite direction is Cherokee County. But anyway. Here we go. So I'm sure that guy's an expert. Then we have a break. Then we have human trafficking in gangs. No space. Then we have a dash, and then we have a space. And this is Amy Hutzel from the Criminal Justice Coordinating Council. We have a retired agent. And then we have a prosecutorial liaison from the Georgia Bureau investigation. Fantastic. Then we have no space here. And then we have a space here. And from 1 to 2:45, we have the Ghostface Gangster Workshop. That is a real gang. It is a white supremacist, I don't know if they're white supremacists, but mostly white gang that originated in Georgia prisons somewhat recently. The feds did a big crackdown on them over the last couple of years. I think they have a lot of members in like southeastern Georgia, the Brunswick area. I know the DOJ did a big bust in Brunswick or Gwinnett County. But let's see who we have. We have somebody from U.S. Attorney's Office. That makes sense. That's a legitimate person. But then we have investigator, GBI agent. Nobody from outside of Georgia. Nobody familiar with this gang specifically, except for maybe the U.S. Attorney's Office. Nobody in the gang. Nobody's, as far as I can tell, has any specialty in gangs. Now we have special guest Vonnie Willis, District Attorney-elect, apparently speaking for 10 minutes, which is 15 minutes too many. Then we have, critical evidence, law considerations in gang and RICO cases, best practices in investigating, charging, and expanding pathways of proof expert panel prosecutors and LEOs, hosted by Michael Carlson of Carlson and Carlson on Carlson on Evidence, who actually worked in the YSL case, and John Melvin, also of the GBI. Let's see. Then we have a supervisor from Georgia Department of Corrections. Let's see. White supremacy, GBI, Spalding County, which is used to be the district of Jose Ramirez. Oh, there's Jose Ramirez. Speak of the devil. literally the devil. Aryan Brotherhood. So you see nowhere in there. Also, I want to point out this second day is like less than half a day. It's maybe 4 hours. So all told, it's really like a day and a half, which is not quite as much as a week. Summer agenda. This is also not really public, but they're bad at security, so we have our certifications. Largely the same thing. We have an ADA from Clayton County. I mean, everybody is internal to law enforcement. There's nobody. Wow, this is a full day right here. We have one. What is this? There's what, 2 hours, 3 hours? Less than 4 hours of actual work on this day. The jokes write themselves sometimes. I'll look this guy up real quick. Don't worry about that. It's not even written by the guy. Prodigy from Mobb Deep. Yeah, I'm never watching that. Anyway. What else do we have? Media and law enforcement from a media company. Oh, really? Sorry, James. Okay, so I think you get the point that the conferences are by and large. Ooh, I need to change this. The conferences are by and large just. Yeah, I saw that, James Steinbeck. Ashley, how to prove we go without an organization. Yeah, seriously. Yeah. So I want to show you how hard it is to pass some of these certifications. Let's go back to some of the earlier ones. This one, maybe? Yeah, here we go. GGIA Basic Certification Course. Personnel applying must meet the following criteria. Be a member of good standing. I think that's like $20. Pay a tuition cost of $100 plus $5 processing for credit cards. Attend the entire 8-hour course. Successfully pass the test with a minimum score of 70% to be a certified gang investigator. 70%. But that's okay. It's just the intermediate. I mean, no, it's just the basic. So the intermediate's probably much more difficult, right? I wonder if I have one of those. Where did I put them? Here we go. Here's a more recent one. 2023. Okay, Georgia Gang Investigators, the Intermediate Certification Course. I assume it's about Woody, the first part. Yes, it is. I ranted about Woody and the water balloons. James says, I want to take the test without the class. I think you can take the I think you can take the class. Some of them are some are law enforcement only, but I think you can register as like a supporter or something like that and take some of the courses. But okay, so this is the intermediate certification course. Here's the very stringent, rigid, just utmost requirements that are feasible, that are imaginable. Be a current member in good standing. Again, I think that's like $20 or $25. Successfully complete the basic. Pay $105. Attend the entire 8-hour intermediate street gang course. Successfully pass the intermediate street gang investigator certification test with minimum score of 70%. And again, remember the context of this. I am making fun of them because it's fun and I enjoy it and I do it for no reason. But my reason here is that these certifications are used as evidence of expertise within the context of qualifying somebody as an expert witness in complex RICO cases. So 70% basic, 70% intermediate in a total of 16 hours of training. I assume that the test is part of the 8 hours. I'm sorry, Ashley, I forgot the $5 processing fee. You got to pay the $5, of course. That's what it takes to be an expert witness. And remember, going back to the Daubert transcript, you know, this is her training. Up here, again up here. So, hey Matthew, do they realize that this is stupid and stop? No, I think they have some new ones coming up actually, last I checked. They're not very good at posting them. I could be wrong about that though. That's driving me crazy. There we go. So, okay. So those are the basic and intermediate. Now, this is... looks like I was going to show this before. Have you heard about McNally versus Proven? I've heard of it. I haven't looked into it yet, though. I know the backstory a little bit. I've seen the video of the can in the Glock. Brunswick. I have a Brunswick case that I've been looking into lately. And by lately, I mean like 2 hours ago. Brunswick's a mess. Brunswick is like smaller Fulton County. This case involves a guy who, the one that I've been looking into, involves a guy who, somebody else pleaded guilty to a murder, or didn't plead guilty, admitted to a murder, and then the guy I've been talking to was actually convicted of it subsequently. And the fact that somebody else confessed wasn't turned over to the defense. But it was ruled not to be a Brady violation, which is fucking insane. But no, I've heard about McNally, but I haven't looked into it yet to answer the question. Okay, let's see. So this is the Miss Marissa Viverito course. They apparently haven't learned that you don't put a period after that for like the last 50 years. Hank Breenans. Fulton County is a mess. Some defendants languish in jail for over a year without an indictment and no plans for that. I want to show you something. This is off topic, but the topic is really just making fun of Fulton County, so I guess it's on topic. Let's see, where is my data? This is a little bit dated. Let me see. Is this one? No, not this one. This one. What is this? Yeah, here it is. This is a quick aside. We're going to come back to the GGIA in a second. This is, I think this is like a month old. Yeah, a little under a month old. But these are the oldest. Well, let me zoom in so you can see this better. You don't need this. Oh, you don't need this either. Why isn't this working? There we go. Oh, my head's in the way. There we go. So these are people who, at least as of a couple weeks ago, were in the Fulton County jail, Rice Street. And you'll see that some of these people have been here for, I mean, this guy's been here for 15 years, 14 years, 11 years, 9 years, 8, 7, 6, 5. So some of these have been, I know you said some have been up to a year without an indictment, but some of these people have been here for over a decade without a conviction, which is pretty wild. Okay, let me just switch back to this. Here we are. And I can show you guys the underlying data for that if you're interested. Angelica says, I want y'all to know I started from the beginning, and I'm really mad at the water balloons. There's so many things that could have been flying out of the window on a hot Atlanta night like bullets. That's a much better way of putting it than I did. I was mostly amused at how absurd it was, but it is serious. I mean, it is a... Angelica said it very well. I believe he was indicted, but he hasn't been tried yet. I think they've been trying to prove that he's mentally fit to stand trial for 15 years, which to me is pretty good evidence that he's not. Actually, you know what? I need to make a note. I'm going to show you guys that case after this. That'll be the next thing I go over. But I wanted to show you this part real quick. This is the GGIA social media requirements, and you'll notice that there's not even a test. You don't even have to get a 70%, to pass the 70% test to get your GGIA social media investigation certification from Mercer Viverito, the professor. I guess they all want him to violate his probation so he can sit in jail. Offense is ticket worthy, perhaps a fine of community service. Yeah, I agree. That's totally fine. Look, Woody does drive a little reckless. So if he gets like a ticket or something for speeding or whatever, I wouldn't be surprised or particularly outraged. But anything over that. This is, I want to show you guys this. This is just kind of funny. This isn't meant to be a dig or anything. It's just funny about how times have changed. Look at the Facebook the apps that they were reviewing back in 2018. Facebook, Snapchat, Instagram, I don't know what this is. WhatsApp. Something called Meet Me. I don't know what this is. Meetup, Twitter, and Foursquare, which I think got purchased by Instagram, right? Why is there no month on the course? Good question. Why is there no month on the course? I'm pretty sure I know what it is, but it should probably be on there. I'm proud of you. That's an excellent question. But this one, more seriously, this is the trafficking course. I'm going to be a little bit more serious about this one. But you'll see, so this is a human trafficking gang investigator certification. So this is serious. This stuff actually matters. Not that the other stuff doesn't, but this certainly does. Center this a little bit. Personnel applying to obtain the GGIA certification. What in the Craigslist type of course is that? It's a good question, Keisha. So be a current member in good standing. Again, that's like $20. Pay a tuition cost of $100, add $5 for processing. Attend the entire course, the 8-hour course, and successfully pass with a minimum score of 70%. You do have to previously have passed the basic course. So think about that. You can be an intermediate certified gang investigator, certified with a certified specialist in human trafficking, never getting more than 70% correct. And you can testify in a gang human trafficking case 70%. 70%. That's what it takes. I don't care for that. I don't think that takes victims very seriously. And I know that Fanny Willis thinks that people like me don't take victims seriously, but I think it's difficult to argue that this organization takes victims seriously. Let's see if there's anything funny I can pull up. This is kind of amusing. Oh, here we go. Of course, just to confirm, you only need to score 70%. I'm sorry, it's actually $25 is the membership. Apologies for the disrespect. This is just a person. This doesn't even look like a gang either. This is just two people not walking together. And this is just a guy by himself. So I don't know what any of these pictures are. Okay. What do we want to do next? Do you want to do a random... review of the Bethlehem, Pennsylvania gang PowerPoint presentation? One of the funniest things I've seen in my entire life. I think Kat's seen this one before. All right, so let's see what we have here. We have neighborhood gangs. So apparently 5 bandanas. This guy's throwing up the I love you. Latin Kings use gold and black. Hey, Heinz, what's up? Latin Kings use gold and black as the main colors. 5-pointed crown, black gold beads, in flags. Rolling 20s. I don't know if the Pyru would like being called a blood set, but that's okay. Yeah, I've been to Bethlehem. It's, let's take a quick look. Not AP. PA. This is the... I'm going to move my face again. Lehigh Valley population 78,000. Let's see, as of 2018, the Lehigh Valley Bethlehem had a lower crime rate than Allentown, but a higher crime rate than Easton. Let's see, in 2018, Bethlehem had a violent crime index of 273. For reference, the United States average was 369, roughly. So significantly below the average criminality of the United States. But, you know, you got to have a gang unit. That's the rules. Nothing says gang like Old English lettering. You know it. Let's see, we get the boys in blue. 8 Tray, Will in the 60s, Grape, the Hoover Crips, accurate. They have Maniac, Latin Disciples. I swear to God, is this the same guy? Nope, it's a different guy. Let's see. Then we have this from chicagogangs.org. Yeah, there are parts of Pennsylvania that can be pretty rough. Like parts of Harrisburg can be questionable. It's Bethlehem, Pennsylvania gangs. Let's see. Maniac, Latin Disciples. Wow, this is very legible. I'm sorry, this is ridiculous. 5 members of the Money Rules Everything gang out of Bethlehem face state racketeering charges connected to criminal activities include homicide. Yeah. Then we have this indent, whatever this is. Reading. I haven't really been to Reading. Aren't we talking about Pennsylvania? We are. I don't know why we're in Chicago. Let's see. Neighborhood gangs are a unique occurrence on the East Coast. I think the Rolling 60s would disagree, but the Hoover Crips might disagree. These gangs are made up of individuals that grew up together in a specific neighborhood. They represent their neighborhood instead of one of the major gangs, but you've just spent this entire PowerPoint spent about major gangs. These gangs may have ties to a major gang. However, they are not a part of that gang. These gangs are not a part of that gang. Some local examples of neighborhood gangs include Money Rules Everything, GMB, I think it's Get Money Boys, OBGG Gang, Cherokee Tribe, which I'm pretty sure the Cherokee are not, legally speaking, a gang. I think that's just like an ethnic group or a people, a nation. In any event, these individuals are real gang members, despite the fact that they are not part of one of the major gangs. Like the major gangs, they will all pick identifiers, colors, symbols, and areas. Look at this. This is just... no notes. This is fantastic. That sounds pretty... It does. It does. What is this font? I love it. Graffiti is often a spray-painted message or slogan that may also contain information on crime, gang activity, group memberships, and clues on authorship. The Bethlehem Police keep a photographic record of graffiti and shares information with other agencies. Graffiti should be reported before it is removed. Just because you may have a lot of graffiti doesn't mean that you have gang activity. Gang graffiti is easily read. This is done on purpose since it is used to mark territory, to disrespect rivals, and to intimidate people in the area. This is, I believe, Latin Kings. Matthew. If you, a king, follow your lit, stop doing drugs and bullying, righteousness and honor. That's good advice. The crown on the top left is an identifier of the Latin Kings. Latin Kings also fall under people nation, so the Folk K is referring to Folk Killer. The down-facing pitchfork is disrespect Folk Nation. ADR stands for Amore de Rey. Okay, I tweeted about this one. This is my favorite. I can't express to you how much I love this. Where would we be without experts to tell us that SMM stands for sex, money, murder? I don't know. This is one of my favorite pictures of all time. I tweeted about this recently. I love it so much. And NHB stands for neighborhood bullets. And 20 stands for 20. Hoover stands for Hoover. The Hoover Crips sometimes say Hoover in their graffiti. Star of David? I didn't expect that. Interesting. GMB stands for GMB. MRE stands for MRE. Some of these are just terrible. Okay, this clearly says Pyru. Bompton. Oh, but that's probably Pyru more than blood, actually. 60s. Oh, I love it so much it hurts. I wonder if the test for the investigation certification is this difficult. Oh yeah, that's a good point, James. The City of Bethlehem PD Gang Unit is involved in investigating gang activity in the city. Makes sense. We work hand in hand with other municipal, state, and federal agencies. Gang Unit shares information with regional intelligence centers. Okay, that was just something I found recently that I wanted to share. I could close some of these. I wish I had changed all of these. So where should we go to next? Lyrics, maybe? I think I want to complain about lyrics for a little bit. Keisha says, paying for the training seems like it is feeding someone's pocket because we are learning the course material now. Yes, that's Jose Ramirez is getting paid out of this. A lot of money, actually. He's the president of the GGIA, and he has his own company that is paid as a for-profit entity that does trainings. Allegedly, but also actually. What should I do next? I think I'm going to complete. Yeah, I think lyrics are next. I think I want to complain about lyrics. But where do I want to start? This is difficult. let's see if I can find the case I'm looking for. This is... Who was it? It's Darren Mills, I think. Georgia versus... There it is. Sorry about this, Wade. I should have had this ready, but I'm kind of freestyling this here. Here we go. I think. I need to delete some of my comments before I show this on stream, because I don't want to get banned from YouTube. Here we go. This is where it gets stupid. Oh, I guess I was just showing you guys everything as I was deleting it. That's great. That was very well done by me. I saw they were, Matthew says, I saw they were nonprofit and were suspicious. Yeah, I can, I'll add that to my list of things. Actually, you know what? I can do that really quickly. I can do that in a few seconds. I can show you guys that information. Let's see, I think it's purchase orders? Vendor payments, maybe? Oh man, I forgot how much work I did on this. Yeah. This is just going to be one example, but I can show you guys that real quick. No, not you. The other one. This one? Yeah. So this was part of a larger project I was going to do. Let me hide some of this stuff. You don't need to see all this stuff. Yeah, I don't need this. Yeah, this is one such payment. This is Jose Ramirez, the president of the GGIA. It's a $2,400 payment to him. And you'll see it's paired with a payment to the GGIA. So he basically uses that organization to drive money to his own for-profit entity. Anything else I want to show you? Yeah, while we're here, might as well get into this. See here, this money for the Sexual Assault Kit Initiative, which was supposed to be used to pay for the testing of old rape kits dating back to the 80s that were never tested. You'll see here what that money went to. This is legitimate. This is legitimate. I'm pretty sure that one is. But everything else went to travel of some sort. So, yeah. That's where the money, that's where the federal grant money's going, in case you were wondering. This was more recently. They actually started doing it correctly to their, I'm not giving them credit for that, but they at least changed their practices a little bit. This is Violence Against Women Act funding. You'll see here. These three, I believe, are legit. This one, I think, is. But you also have these three are just general expenses that really shouldn't have been in there. But again, you have a lot of training money in there. Post-conviction DNA, none of this is going to, actually no, two of these are going to legitimate expenses. But for the most part, they're not. Or I'm sorry, more than that. These are this one. That's this one. These ones. These are legitimate. But as you'll see, many of them are in fact not. Justice Assistance Grant from 17 to 19 is being used for transportation, like shirts, swag, basically nothing. More stuff. This is also all travel. These look legitimate. Gang prevention program. This is one of my favorites. They're funneling money out of the federally funded gang prevention program and paying it to the Atlanta Police Foundation. Total, let me see, $73,000 over the past 2.5, almost 3 years. It's very legitimate. Then we have our confiscated funds, paying $68,000 to Nathan J. Wade. I'm not sure who that is. The name sounds familiar, though. Oh, wait, no, I missed this one. So it's actually more than that. It's actually, what? $103,000, I think. Now we have community violence intervention. Let's see, we have a $14,000 payment to MTI Limo. This looks legitimate, at least. Oh, also, I had this one more I saw in here that I recognized. This is the firm of, I think, Michael Carlson, who was brought in for the YSL RICO case. So you can also attribute this to YSL. The cross firm, I can't remember what they are. I think they're legitimate, though. But I hope I was showing that this whole time. Yes, I was. Okay, good. Keisha, no, I did that myself, actually. You can get just like the raw data, but I all the organization color coding I did myself. I've done a lot more, actually, to be honest with you. I can probably show some more. Ooh, this is actually a really cool one. I'll show you guys. Let's see if I can pull it up. You know, I'll do it in the original, actually, so you guys can see how I do this stuff. This is a little self-indulgent, but some of you might find it interesting. I think I've showed this before, actually. Yeah, here we go. Browser. Fulton County. There we go. This is actually probably my favorite thing I've ever done. That hasn't led to me working on an actual case. This was like the coolest thing I've found so far. Go back to Excel real quick. Is purchasing orders. Okay. So I just downloaded this. This is purchase orders from I don't know what the dates are exactly, but this is all raw data that is the sort of thing that I sort of itemized or categorized in the last spreadsheet that you saw. Some of the stuff I'm just going to hide. You can see here there's, I mean, it's a pretty expensive data set. It's about 25,000 lines of purchase orders. Let's see if I can just pull the ones I want. Here we go. There's one here. Here they are. Yeah, I definitely, now that I think, the more I think about this, I definitely showed this on a stream at one point. Zoom in a little bit, show you. But yeah, so these are purchase orders made by the district attorney's office. And I found these, I can't remember why, but I found these case numbers. I didn't know that this one was case number. This, oh, to move my face again. There we go, what's up down here. Ooh, my hair looks crazy. Yeah, I didn't realize that these were case numbers. These two right here. But eventually I looked up this one because I was curious. And I'll show you how I did that. Here we go. I hate this one. I hate the beds one. Because this one doesn't seem like it's a bed. Okay, good. So after I found that, looking through the purchase orders, which one was it? 3, 4, this one. I pulled up this case. Actually, there's a familiar name. Oh, yeah, right here. A familiar face. But anyway, if you go all the way down to the bottom, wait, what? I haven't seen this one. I haven't looked at this in a couple months. I have not seen this before, so we're doing it live. Woof. You're just gonna have to watch me read this. This is the date of the YSL indictment, the first one. This guy's a really good writer. Sorry, you can read along with me. That's interesting. Well, we're getting sidetracked. We're going to something different now. I'm sorry for being all over the case, but you're just going to have to watch me do this in real time. I'll try to share my desktop, more or less, so you can see what I'm doing. I'm going to share my screen so you don't miss anything. If you're not interested in this, that's completely understandable. But I kind of want to work on this now. So maybe you can see what I do. Not that one. The other one. Okay. So it was Jacques Shockley who wrote that. Okay, so I need to give you a little bit of backstory on this. So there was a case in 2005. Hold on, let me see if I can find a good case I can read for you. Another familiar face. Sorry, guys, I kind of got short-circuited there. I'm really curious to see if anything came of this, because it's a case that I've been really interested in. Oh, my mic's very low. Hold on, I can fix that. I think I was just talking very low, to be honest with you. Is that any better? It should be louder. That's right, factually. Okay, great. Angel. Okay, I hope it's better. I usually try to check it beforehand, but kind of got thrown off there. Okay, great. So I guess I can just tell you, basically, there's the issue with this case is that there were three people in a car. It seems clear that one of the other two killed the driver. The state never established who the shooter was. There was somebody in the back seat behind the driver, and there was somebody in the passenger seat. The state never decided. I don't think the state even alleged which one the shooter was. They just said one of them was the shooter and the other one is guilty under a theory of sort of conspiracy liability. The person in the back seat, who I believe was Powell. Let me make sure that's right. Or was it Shockley? Yeah, I believe Shockley was the one in the back seat. And so the guy in the back seat, Jacques Shockley, is basically saying that he didn't plan on this, he didn't do it, and part of his case is that the Georgia Bureau of Investigation's ballistics expert is a woman named Bernadette Davy. That's correct. That's a thing that happened. I will just read through this for you, and that will give you some sense of the case. Jacques Shockley. Brief of argument. Now comes Jacques Shockley movement. Herein, by special appearance and without subjecting himself to the jurisdiction of this court, only for admissibility. This isn't real, but the rest of it's good. Movement seeks relief by this court from a sentence imposed by Fulton County Superior Court, and this court has judicial jurisdiction to address this brief of argument pursuant to 17-9-4. That's the code section. Why? That's a good point, Grace. On July 1st, 2005, I was arrested by 2 officers of the Atlanta Police Department. The 2 officers, while acting under the color of law to enforce statutory policies, violated my civil rights by falsely arresting, false imprisonment. My liberty was taken from me. It's still happening. Crowns. Count 1. The movement, indictment, and warrant failed to allege the essential elements to grant a warrant or indictment. There was never a gun nor a fingerprint that linked me to this crime whatsoever, but the judge was signed... The warrant was signed by the 2005 judge. At the same time, the state had movement locked up at the age of 17 years old. And it was a firearm examiner in this case named Bernadette Davy, who was a GBI investigator, and was forced to resign from her position with the GBI because she intentionally fabricated data on firearms worksheets. That was part of the official crime lab case files. And Ms. Davy lied in the beginning of my case to fit the state's theory of the case, and even though she didn't testify in my trial, Linda Donikowski and Paul Howard, the head and ADA, still used Ms. Davy's theory of the case, of what took place with the gun, and how it was so-called used in the case before there was an indictment. Therefore, since the indictment is effective and void, this isn't really an effective argument because that's not a defect in the indictment, it's a defect in the evidence. Yeah, that's right. This was written by Jacques Shockley. For always. This was written by the inmate himself. So he's not really arguing the right theory, but his point is valid that his case depended and incorporated evidence from Bernadette Davy, who was disgraced and forced to resign. Let me go down a little bit more. The whole reason for getting a so-called true bill of return was based on Ms. Davy's theory of the case, because no gun was found, no fingerprints, no eyewitness to place him at the crime. Let me see. The state knows before my trial, Ms. Davy resigned because she fabricated data. True. Hold on. Void. Movement was given a lifetime in prison for a case that was never proven against him. Judge Arrington was the trial judge. Yeah. You'll see here, this was actually quite recent. 15th of January 2024. Copies to, this would be Judge Glanville and Fonnie Willis. He is in Hayes Prison. Here we go. This is where it gets good. And by good, I mean bad. This is the letter concerning Bernadette Davy. Dear District Attorney, this letter to inform you of a recent personnel decision at the GBI Crime Lab that may impact the prosecution of cases by your office. Effective April 1, 2009, Bernadette Davy, a firearms examiner, resigned from her position with the GBI. The resignation resulted from the findings of a GBI Office of Professional Standards investigation, which determined that she intentionally fabricated data on a firearms worksheet that was part of the official Crime Lab case file. This is the indictment here. Linda Donikoski. That's Jonathan Odin. I don't recognize that one. This is his sister, wasn't Gant? Or is it? I can't remember who that is, actually. Jermaine Jackson, J.D. Smoot, Powell, Alice. Josh McBurney. Anyway. How many times has she screwed people? They're still... I talked to somebody in Georgia, a Georgia lawyer, and she said that they're still just getting started on Bernadette Davy cases. Campbell says, it's like that lady in the drug lab in Massachusetts that was using the lab drugs, but all the cases his name on were thrown out after she was found guilty. Yeah. There were two ladies, actually. One was in like the Boston area, and the other one was in Western Mass. What was her name? Shaw, I think? I just rewatched that documentary recently. Shockley. This is the other defendant here, Marquez Powell. I think this is Max's client. Or former client. And you'll see here, this is, I believe, I don't know, Rachel Carnesale. But, yeah, denial of motion for new trial. So, anyway, taking it all the way back to the beginning, the reason I thought the DNA thing was so interesting was that in 2022, somebody at the DA's office was requesting DNA sampling information on that case. I'm going to move my face again for like the 18th time. But I couldn't find any information on the docket, any corresponding entries on the court docket showing anything happening or any results or anything to even cause them to do this kind of DNA testing. And so that is what caught my interest. So we have unexplained DNA testing, and we have a disgraced Georgia Bureau investigation, firearms examiner, and a firearms case, a shooting case, when we don't know which of the two defendants was the shooter. So that is some of the stuff that got my attention. No, not that one. Shockley? Yeah, his date of birth is... I think he's like a month older. I think he's like a month older than I am, actually. And he's been in prison since he was 17. So essentially, we're about the same age. But my entire adult life, our entire adult lives, I've been free and he's been in prison. And sometimes I think about like everything that's happened to me since I was 17, since we were 17. And he's been in prison for that whole time, and I've been outside for that whole time. And the only reason is, well, not the only reason, but a substantial part of the evidence justifying that difference is the testimony of a disgraced, or not even testimony, he wasn't even allowed to testify, the evidence created by a disgraced firearms examiner. And apparently now a mysterious DNA test that doesn't exist anywhere except in some obscure purchase order. So that's why that case is interesting to me. Okay. Well, That was nice and self-indulgent to me. All right, I think I'm going to wrap up with this detective dentist stuff because I'm just getting depressed now. Not this one. I'm so mad. Oh, goodness. It's this dumb one, isn't it? Of course it is. I should add that the state just lost this because Kyle embarrassed them in front of the Supreme Court. Thank God. So that's a little bit of context for you. Here we go. Let's see, I don't want to read too much of this to you. Okay, I believe I've shared this with Kat before, so she can yell at me if I'm wrong about something. Okay. Here we go. So this is a case that is YSL adjacent. These are supposedly, I have no idea if it's true, but they're supposedly members of the gang, of If Gang, the opposition to YSL. Again, I have no idea if that's true, but that is what they say. So this is going to be Detective Tyrone Dennis, who some of you may remember for being terrible. Okie dokie, let's see. Co-defendant White, this is Quatez White, also made, aka Spaz, you may see that. Co-defendant White also made a number of gang-related posts, as well as some posts specifically referencing these crimes. This is allegedly related to a shooting of a drug dealer named Hassan Pope, who was actually, after this, arrested by the DEA and the Federal Department of Justice in connection with a drug distribution ring. So he was, after this attempted murder, he was actually put away by the feds. But, yeah, so let's get into this. Co-defendant White made a number of gang-related posts, as well as some posts specifically referencing these crimes. So again, remember, these aren't, references, like in the YSL case. These aren't references to YSL or, to slime or whatever. They're saying that these posts specifically reference the attempted murder of Hassan Pope. So, among these several photographs of White Mills and co-defendant Dominique Carter, aka Stewie, making Katie Gang and If Gang hand signs. Co-defendant White's post saying that if you're going to sell dope to get it, drug money, it can buy what you want. I can't remember if this is one of the ones. Drug money can buy what you want. Drug money, it's going to buy what we want. But okay, maybe that one's just a coincidence. That one's probably just a coincidence, right? Okay, let's go to the next one. Co-defendant White's post made 9 days after the attempted murder of Pope, stating, apology, there's no way to not say that, so I'm just going to have to. Future. September 20th, 2015. Hold on, what page is this? 24. I can't remember the exact date. Okay. So the events in question are September 7th, my birthday, September 17th, 2015. So 9 days after, it would be September 26th, 2015. Oh my god, this is so annoying. I hate you so much. Crime rate's going crazy because my young friends are so thirsty. Again, this is not a general. No, I was not born in 2015, September 17th. But you'll see the date that this was released was September 20th, 2015. So Cortez White posted these lyrics the week that the album dropped. And it's not like we're talking about some obscure album here. It's Future, maybe the most commercially successful musician to come out of Atlanta. I don't know, certainly in the last decade, 2 decades probably, unless I'm forgetting somebody. I probably am, but certainly one of the most successful, commercially successful mainstream rappers in Atlanta in recent history. And it's a brand new album. It's the week of. The post, like, how do you not check that? And again, it's not a general, if they were saying it has something to do with crime in general, that would at least make sense, but they're saying it's specifically tied to the attempted killing of Hassan Pope. And it's a Future lyric. I'm confident that if I search this next one, it's not also going to be a lyric. I'm sure that. Wait, actually, I don't think it's this one. No, it's not. It's from Lil Haiti Baby, I believe. So this one I'm not sure about because it came out. The album it was on came out after, but I'm guessing it came out as a single. But I could be wrong. Shoot it up in broad day. He's shooting broad day. That little Haiti baby. And remember, these guys they're Haitians. They're supposedly a part of Haiti Gang, which is a subset of If Gang. So you have people who are allegedly a part of Haiti Gang referencing a song called Little Haiti Baby that came out around the time that directly tracks the lyrics. So 3 for 3. 3 for 3. They haven't gotten one thing that is actually a lyric as opposed. They haven't even recognized that these are lyrics. They think that these are explicit statements about the killing of Hassan Pope. This one is Boosie. I think. I'm not positive. I haven't searched this before. Specifically referencing these crimes. And you know what? Now, I just thought of something else. They didn't even kill the guy. He survived. So, it's a good point, James. How could Whole Click Murder 1, But We Walk Us Be Solid explicitly relate to not killing somebody? That doesn't even make sense. And these are all Quatez White, apparently. Ugh. 2 weeks after the attempted murder of Pope, saying that got Stewie with us, that's Dominique. He's going to bust for no reason. Hashtag facts. I have absolutely no idea why he was allowed to opine on the meaning of that. That's fucking insane. I can't. That does not require expertise. It speaks for itself. Whatever lawyer argued that that's an admissible or proper use of an expert witness should be disbarred. I'm glad, Angelica. I'm glad to hear that. Yeah. Let me see. Free D and Stewie refers to... Yeah, that's actually just... That's straight up incorrect. D and Stewie refers to Mills and Carter. White is... Quatez White's nickname is Spaz. So this is just objectively wrong. So good job, Fulton County. You don't even know your own theory of the case. Excellent work. Co-defendant White's post, made after White was indicted in this case, appeared in court stating that looked at the judge guilty as fuck and told her that I'm innocent. So that apparently explicitly refers to the attempted murder of Hassan Pope, despite not using the words attempted murder, Hassan, or Pope anywhere in there. But that makes perfect sense. So, literally wrong about every single one, except for maybe this one. And this one, they're also wrong about, just for different reasons. So, this one is an improper use of a witness. This one's objectively wrong, because they don't know it's a lyric. This one, they're wrong, because they don't know it's a lyric. This one, they're wrong. This one's wrong. And this is literally just pictures. You should know that the Hassan Pope who was shot is actually not in a gang that opposes If Gang. So even like the gang theory of the case doesn't make sense. It's just nonsensical. So I'm pretty sure this one also is a lyric, actually. Let me make sure. It is. In fact, you know who wrote this song? This one's quite fun. It's your boy. I don't know if YFN Lucci has any affiliation with If Gang in theory or in reality. I can't remember anything along those lines. Hey, Keisha. I'm glad you're around. But yeah, it's a Lucci. It's Lucci. It is YFN Lucci. Shout out to Drew Findling, by the way. Good work on that case. I hear he's joining Melly's defense team. And by joining, I mean slowly taking over. Photograph of Stewie's face tattoo, which is an acronym for Haiti in Peace. Yes, that's... How dare he? How dare he? I'm pretty sure this is also a lyric, but I can't remember if it is. I don't think I could find it the first time. Yeah, I can't find this. I don't recognize the lyrics. But yeah, fortunately, Kyle Armstrong. No, Kyle. He humiliated Fulton County for the umpteenth time. Where are you? There you are. Winchester. I don't know why I thought Armstrong. That's the evil one, right? Anyway, yes, Winchester. The one who's been to Wakanda. That's an inside joke. I hope some of you get that. Hold on, let me... There we go. I think I'm going to watch this, and then that will be the end of the stream. You guys can't hear it? Okay. Oh, I know why. I can just do it in a different way. Oh man, I gotta redo my head again. I'll redo this guy actually. All right, let's see.
Court of Fulton County. We've raised 5 enumerations of error, but I requested oral argument on the first one, and the trial court, to explain why the trial court erred in this case by not granting a new trial after it was revealed that one of the pettit jurors that decided the case and voted on the verdict.
So yeah, I think I'm going to watch this with you guys, and I'll probably be done with that at the end, because I'm starting to lose my voice. But this one, it makes me happy inside.
I was a convicted felon at the time.
Oh, let me know if you can hear this.
And there's 3 reasons why that's the case. The first is that the Superior Court's order relied primarily on federal case law, where Georgia common law applied to the remedy for the violation of 15-1240. The second reason is that to the extent there were any Georgia cases cited in the order, those cases predated the operative statute that applies in this case, and they dealt with distinguishable circumstances. And then the last reason is that there was no evidence of knowledge from which waiver or some strategic reason could have been assigned to Mr. Mills for not objecting during the trial. This was discovered after the trial. Sometimes when you do an investigation into juror misconduct, you're looking for one thing, but you find something else. And that's what happened in this case. When Mr. Mills was convicted, I was retained, and we filed a motion with the trial court to get access to the juror list so that we could investigate some comments that were made by an alternate juror on the record, Juror 39. And after going back and forth with the trial court and the state in that matter, the list was produced, and we did an investigation into the pettit jurors. Through that investigation, it was determined that juror number 6 was convicted in '95 of possession of cocaine in Fulton County. She was sentenced under the First Offender Act, but subsequently violated before she completed her sentence. And the judge that conducted the resentencing revoked the first offender and sent her to prison for 13 months. At the motion for new trial, we subpoenaed her. She testified. She was honest about that fact. She authenticated the convictions, agreed that it was hers, and although she testified, she had no, nefarious intent for not answering the trial judge's general voir dire question about eligibility and status as a convicted felon. Her answer to that question, as the trial record reflects, was nonetheless incorrect and not truthful. So it's a clear violation of 15-1240, which says that a person who's been convicted of a felony shall not be eligible to serve on a jury. And I think the question for the appeal is, what's the remedy? The remedy is that the verdict is void and a new trial is required, because under the cases interpreting prior Georgia common law, that the mere ineligible status, absent evidence of knowledge or waiver, requires a new trial. And the reason it does is that these common law cases interpret an ineligible juror as reducing the quality of the jury from 12 members that the Constitution requires in paragraph 11A to 11 members. And so, I guess as colloquially as it could be put, Mr. Mills and his co-defendants had a jury of 11, not a jury of 12. The two...
Help us with this. Were other co-defendants in this trial?
Yes, Your Honor.
How many total, do you remember?
2. There were 3 co-defendants total, 2 independent of Mr. Mills.
Is it clear to you that Ms. Lattimore, I think was her name, was in fact a convicted felon?
Yes, Your Honor.
There's no question about that.
The certified copies of her disposition are in the record. I think it's clear.
If we end up agreeing with you, do you think there's any need to address the remaining enumerations?
No, Your Honor.
Nope.
No, I don't. I'll touch a little bit on some of the cases that were relied upon by the trial court and the state's opposition to our appeal. Specifically, Bennett versus the state and Keever versus Dellinger, which is a civil case, both from the Supreme Court. There's 3 reasons why these cases don't foreclose Mr. Mills' challenge. The first reason is what I said earlier. They predate the enactment of 15-1240. Prior to 2012, there actually wasn't a Georgia statute that unequivocally made convicted felons ineligible. It just gave, you had your section 163A opportunity to strike them for cause if you knew they were a felon, but there wasn't a statutory basis for ineligibility. Now there is. That applied to Mr. Mills' case. The second reason is those cases also dealt factually with distinguishable circumstances where the knowledge of the ineligible status was made apparent to the parties prior to the conclusion of the trial. I think in Bennett, it was made known to the parties at the sentencing hearing, and there wasn't a timely objection. And then in Keever, there was also a knowledge issue. So we don't have that here. I think trial counsel's testimony at the motion for new trial was that he had no knowledge of that. I think his words were, I wouldn't have known that. And so those reasons don't apply. There's no waiver by Mr. Mills. In fact, the only way this was even discovered was through Mr. Mills's protestations after he was convicted to gain access to this jury list so that he could investigate these things. So I would say that those cases are all distinguishable for those reasons. The statute wasn't enacted at that time. There's no evidence of untimeliness or waiver, I think the third reason was that those convictions might not have been. Well, Keever was a civil case. That's another distinction. But in the case at bar, the statute was clearly violated, and I think applying the cases that require the common law remedy, the clear remedy is to void the verdict, and a new trial would be required.
So in your brief, you mentioned that there's a case up in front of the Supreme Court.
Yes, Your Honor.
Amber, do you know anything more about the status of that?
Yes. So oral argument was held in Inbert last week on December 10th, and Imbert is somewhat, it's analogous in that the trial court there found that a convicted felon had served on the jury, and he granted a motion for new trial on that basis. The ultimate issue in Imbert is distinguishable because there, on remand, the defendant filed a motion to dismiss the indictment, and the question is whether that voided verdict counted as a trial for purposes of the Sixth Amendment. So it's not completely analogous, but it does aid Mr. Mills here, because I'll note that during that argument last week, the official position of the prosecuting attorney's counsel was that there was no dispute that Ms. Imbert was correctly granted a new trial based on the felon juror's presence during the first trial. So the ultimate issue doesn't directly bear on Mr. Mills's case, but I would say that concession from PAC during the argument supports his appeal here. Mills's case is the first step of Imbert's, not the second.
Got it, thank
Do you happen to know what the status of the other two defendants' cases are? Are there still motions for new trial pending?
Yes,
Obviously,
Your
it
Honor.
doesn't relate directly to what we're doing today, but I'm just curious.
Yes, Your Honor. The status is that they're both still in motion for new trial status.
He's talking about Dominique Carter and Quatez White, Stewie and Spaz.
Trial court didn't hold a joint hearing. They were proceeding at their own pace, as they say, and so I'm not sure if there have been rulings on those motions, but I know that those cases are not on appeal yet.
I just want to stop and jump in here and say one thing. This is the most awkward part of oral argument, is you have an allotted amount of time, and they will just jump in and ask questions, but then the questions, sometimes it can be several questions in a row, and they'll stop, and then you have to just decide where to pick up, or remember where to pick up, and evaluate how much time you have, and decide whether you want to continue with what you were doing before, or jump to a more important part. But this is one of the most difficult parts of oral argument.
If there are no further questions, Your Honor, I'd yield the balance of my time.
Great, thank you.
May it please the Court, Presiding Justice Doyle, Your Honors. My name is Kevin Armstrong, and I'm from the Fulton County District Attorney's Office, and I represent the state in this matter. Now, before getting into the law, I'll go over some of the questions that y'all had about the other cases. State versus Imbert is not analogous to this particular case. There are certainly issues of overlap. However, in that particular case, Chief Judge Lockett in the Dougherty County Circuit found, as a matter of fact at the hearing, that the juror was dishonest, from which you can imply bias. And so it was correctly granted the motion for new trial in that case because you were entitled to a impartial jury. And as courts across the country have decided, is that the way that you determine that is you look first to whether there is a dishonest answer in the sense of an intentional dishonesty, a lie. From that, you can imply bias. Judge Lockett found in Imbert that the juror lied. Here, Judge Dunaway found the juror did not lie, that the juror was being honest. And under the case law that I've cited to this court about impartial juries, that's something from which the court was perfectly authorized to conclude that the defense had not suffered any in violation of his right to an impartial jury. The next
Counsel,
fact,
don't you think that there is a significant difference that the Georgia statute makes jurors who are convicted felons ineligible?
I do not, Your Honor. I see that as something that basically goes to a juror's qualification similar to their citizenship status. Although citizenship status talks about qualification rather than ineligibility, that is another statute that exists outside of the strikes for cause statute, and that's something that this court in Moton versus State had decided was basically goes under the rules propter defectum, which
What
is.
year was that case decided?
That case was 2002.
So tell me a case that's been decided since 2012 that's held that.
So, Your Honor, I was actually talking about the separate citizen issue. So the citizen issue has only been moved its statute number. But I do not have a case specifically since 2012 on this issue. But basically the defense is asking this court to leapfrog a number of cases to go back to common law as opposed to dealing with things that have happened since then. And so I would just like to, I apologize, I just want to go over one fact issue again. You asked about the status of the two co-defendants. One has had his motion for new trial denied. One is still in the motion for new trial status. So one will be coming up to this court soon.
Was this issue raised there?
Yes, they adopted the record developed by Mr. Winchester involving the Juror 6 issue. And so it has the same issue involved as well.
So if this juror had come in and said, oh yeah, I lied about being a felon, then it would have been, then we've got a problem. But because she forgot and was honestly not trying to, I guess get on the jury for some nefarious purpose, then it's okay for her to be on the jury?
Yes, but it's not quite in those terms. So since McDonough, a U.S. Supreme Court case in the mid-'80s talking about the core right to a impartial jury, courts across the nation, including Boney from the D.C. Circuit in '92, and I believe a different circuit, don't remember which one, in the Hanna case, I believe it is, in addition to a number of cases across the nation, they talk about if the juror is dishonest in answering, that's something from...
Okay, you guys probably picked up on this, but his face is very telling. The judge on the left. There's a specific Georgia statute, and he's talking about federal law and federal case law, and Georgia case law predating the statute, and that is why they all look unimpressed as I say this.
Which one can infer that they are biased, that they are not impartial. But if they are not dishonest when they answer questions, when there's no intentional dishonesty, then that's something from which the court could find that there was no intentional dishonesty and that the defense has failed to show bias, because the touchstone of an impartial jury is whether you have a jury free of bias.
But why is that relevant when we have a statute that says you're just not eligible to be on a jury if you are a convicted felon? And it just says, it's pretty clear. There's no language in there that says, unless, of course, you forget and you're not lying about it.
Correct.
So why does any of that matter?
So in the McDonough case from the U.S. Supreme Court, it talks about everybody is entitled to a fair trial but not a perfect one. And there's a hostility that's been described in the McDonough case towards new trials for reasons involving simply just some issue with a juror. And that's something that we see in other cases, including in the state of Georgia. In the state of Georgia, which, because we have the statutes, no longer is a matter of issue of just common law. So you have the Kiefer case and you have the Bennett case, in which even under older rules, where you was basically using the phrases involved in objections propter delictum, that basically they held that in those cases the offenses were not so infamous or recent to require a new trial. So there's never been a rule, in my lifetime at least, that if there is a felon on your jury, you automatically get a new trial. That has never been the law. That is not the law now. That is not the law from this court or the Supreme Court. And so you have those cases. In one case, in the Bennett case, it was a habitual violator felony. The person was convicted of a felony from several years before trial. The Supreme Court held that's not so infamous and that's not so recent as to be something that affects the fairness of the trial. In Kiefer, which was a civil case, you had a prior drug felony from years before. Here we have a decades-old drug felony. That's not something under Kiefer would be so infamous or so recent as to infect the fairness of this trial.
But does the statute say, well, you're ineligible to be a juror because you're a felon unless it's been more than 15 years or it's been a long time?
The statute does not say that, because most statutes, you don't have an automatic new trial just because a statute is violated. Again, you are entitled to a fair trial, not a perfect one. And so under this court's case law, I mentioned earlier propter delictum. That was the old common law. When there is a statutory disqualification or qualification requirement, that's something that falls under objections propter defectum. There's some defect involved.
I'm sorry. We got to hear that again. That was just too good.
You don't have an automatic new trial just because a statute is violated. Again,
Eligible to...
That's not something as to be something that affects the fairness of the trial. In Kiefer, which was a civil case, you had a prior drug...
You see your face? How can I zoom in on that? I wish I knew more. Oh, man. We just need to see her face again.
That's not so infamous and that's not so recent as to be something that affects the fairness of the trial. In Kiever, which was a civil case, you had a prior drug felony from years before. Here we have a decades-old drug felony. That's not something under Kiever would be so infamous or so recent as to infect the fairness of this trial.
But does the statute say, well, you're ineligible to be a juror because you're a felon unless it's been more than 15 years or it's been a long time?
The statute does not say that because most statutes, you don't have an automatic new trial just because a statute is violated. Again, you are entitled to a fair trial, not a perfect one. And so under this court's case law, I mentioned earlier propter delictum. That was the old common law. When there is a statutory disqualification or qualification requirement, that's something that falls under objections propter defectum. There's some defect involved in it. And basically in Goss, which is cited in the state's brief, this court tied the strikes for cause statute to objections propter defectum. Now again, this is not since 2012. I want to be very open from that. You also have in Jones where this court basically applied the rules to object.
They have all decided against him by now. They've already all decided the case.
Propter defectum to a felon on the jury case. And that's something where this court did not grant a new trial. Granted, there was other reasons as well. The court applied the rules of objections propter defectum, which one must raise at trial or you don't get to raise it. Because they cite, I'll pause, I'll say that in just a second.
This makes no sense. If you don't raise it at trial, you don't get to they didn't know at trial because the person didn't disclose that they had a felony. It doesn't make any sense.
And so this court used those rules, but ultimately said, and even if it wasn't waived, then still they failed to prove it. And so there is another basis that the defense has pointed out for the Jones case. I would like to point to Allen versus State, which is a 2009 decision from this court, where basically...
Is 2009 before or after 2012? I think it's before.
The court talked about why it is that if there is something that you don't realize about one of the qualifications of the jury, that you still are expected to object to that at trial, or else you don't get to raise that later, such as you can when you have an issue of juror bias that you didn't know about.
I mean, you're just supposed to say, before they start, okay, and I'm going to object generally to the extent that any of these jurors might be felons and they've forgotten.
You'd raise it specifically to an individual. And so I'm not going to say that it would be perfectly...
I love her. You're going to hear that again.
...about.
I mean, you're just supposed to say, before they start, okay, and I'm going to object generally to the extent that any of these jurors might be felons and they've forgotten.
You'd raise it specifically to an individual. And so I'm not going to say that it would be perfectly easy, but that is something that I would like to read a quote from Allen, which is not in the state's brief. There are quotes from Allen in the state's brief, but this is an additional one. Since Gormley, which is referring to Gormley versus Laramore, an 1869 decision by the Georgia Supreme Court, Georgia courts have consistently held that objections to the manner in which a jury is chosen, when such objections do not relate to the favor or bias of the juror, but rather to his or her qualifications to serve on a jury, come too late when raised after the verdict is rendered, even if the defect was not discovered until after the verdict. That is this court's own decision, that's this court's language that I'm citing to. And so we would have to ignore those cases in which the Supreme Court said not so infamous, not so recent, while applying the old law, and we'd have to ignore this court's case law on objections propter defectum. Granted, the 2012 statute exists since those decisions, because we haven't really had this issue come up. It's unusual that you have both Imbert and this case come up all at the same time.
Yeah, it's a good thing we have a statute that's directly on point that explicitly tells you what to do.
And so...
Can I ask you a couple of the questions I asked opposing counsel?
Absolutely.
Do you agree that the juror 6 was in fact a convicted felon?
I believe that was a finding of the Superior Court, as well as her being not dishonest, and to be honest.
So that was yes?
That was a yes, Your Honor.
We can hear that again.
The juror 6 was in fact a convicted felon?
I believe that was a finding of the Superior Court, as well as her being not dishonest and to be honest.
So that was yes?
That was a yes, Your Honor.
Okay. And do you think she either failed to, she was asked the question, the panel was asked the question, are any of you a convicted felon, correct?
Correct.
Do you believe that, or do you concede or not concede that the change to 151240 in 2012 effectively overruled Wright and Keever?
So I think that Wright v. Davis, the 1937 decision, was overruled before that.
Okay.
By the 1995 addition to the strikes for cause statute that included the convicted felon. And the reason for that is in Wright versus Davis, they talk about in the absence of organic law, we're going to apply the common law.
He's yapping.
And so given, once the legislature finally started to inject convicted felon issues into the statutes, that took it out of the common law and made it an issue of statutory law and a matter of statutory violations as opposed to the old law.
Okay.
I would like to add an issue with that, and that is the case that we just mentioned, Wright versus Davis, talks about an impartial jury. At that point in time, both the common law and
Yeah, what time is that? Like 1776? What are we talking about here?
as referred to by Mr. Winchester in his, I believe, his reply brief, but also the Georgia State Constitution read differently than it does today. Then it read, when it got to the issues of the laws the General Assembly would create for jury selection, it referred to intelligent.
No, this guy's actually argued hundreds of appellate cases. He's their lead appellate attorney.
And upright men. And the convicted felon issues went to that upright men thing. In 1983, I should say language, not thing, I apologize.
No.
That language was not imported into the 1983 Constitution. At this point, we have it just, the General Assembly shall provide for law for the selection and compensation of persons to serve as grand jurors and trial jurors. And so all Georgia constitutions have had the law on the right to a trial should remain inviolate, just as the Wright decision had said. But the ones that I've looked at least the 1877 and the 1945 one, had that upright men issue within the Constitution of the state of Georgia that is no longer a part of our Constitution. So that's another difference between what Wright was applying in the absence of organic law, so to speak, and what we have today. At one point, I believe Your Honor was asking me if I believe that
You should have called it.
been dishonest or had been
Failed
mistaken.
to answer or whatever.
It was a failure to answer that was an honest failure to answer. It was something that in trials we see where when you ask an entire panel something, for whatever reason, the person doesn't understand the question or doesn't hear all of the words or doesn't put it together that what she had was a felony. And so it was an honest.
It was a cocaine charge. It was a felony.
She was intending to be honest in her answers, which I believe was her testimony at the motion for new trial. And she was, again, as Mr. Winchester pointed out, when she testified at the motion for new trial, she was honest. Yes, that's my conviction. And so the Superior Court, who had her before her, who could judge her demeanor and her answers, as well as get any other extrinsic evidence on the issue, determined that she was not being dishonest, and that's why the court was allowed to apply the law that it did. I would mention that one of the issues in the Imbert case is that it's not just a matter of somebody coming in and saying, oh, I was being truthful or I was being untruthful, and you have to accept their answer. You have that demeanor issue, but you also in Imbert had extraneous evidence because Judge Lockett found that this juror was not being truthful because when he said, oh, I thought I had my rights restored from that one conviction, he had a second conviction after that. And so from that, Judge Lockett drew the conclusion that this juror was not being honest when he responded that he did not have a felony conviction. And so those are material differences. If there are no further questions, I would simply ask this court to affirm the Superior Court in this case.
I want to jump in. I'm trying to remember exactly what Keever said, and that was a civil case. But would the outcome in Keever have been different if 151240 applied?
That's Purely speculation on my part. I don't believe so, because even if you were to apply the old common law about infamous crimes, in Kiever, they actually addressed it. I think they addressed both. I think they basically said, not so infamous, not so timely. They might have used those exact words. And then they go on to say, and the defendant has not shown that his trial was unfair. The law that I focused on is how you show a trial is unfair, using that issue with whether the juror was responding
Unfortunately, there's an actual law rather than the law that you focused on.
dishonestly to an answer which, if answered correctly, would have been the basis for a motion to strike. And so you had both of those, I believe, in Kiever, but Kiever definitely said that it was not so infamous and not so recent. It does not say the specific number of years, I believe, that it had been since the drug felony, but here you have a drug felony from the mid-'90s at a trial more than 20 years later. Thank you, Your Honor.
Thank you.
You have some time for rebuttal.
Okay, he's just going to come up and just victory dance for about 5 minutes.
On the question from Judge Markle about Kiever, I'll note there is a footnote 4 of that decision where the Supreme Court specifically states that there's not a specific provision in the civil context as there is in the criminal. So, interesting distinction for the hypothetical that was posed.
Can you restate that? I'm sorry. In Kiever,
In Kiever, footnote 4, the court makes a distinction that there's not a statutory prohibition for the service of for this same problem as there is in the criminal context. So, to the question about do you think the outcome would have been different, that could have been a reason why the court included that language in footnote 4. Concerning the distinctions about dishonesty from Ember, I think the same inferences can be drawn from this case, because at the motion for new trial, the juror said that when she was revoked, she was sent to prison for 13 months. So if you're wondering whether you know you have a felony, you were sentenced to 2 years for a crime, and then when you violated, you went back, and then you got sent to prison for the second time. I mean, I think the same inference.
I mean, you can go to prison under first offender, but I think she specifically said, I knew I was a convicted felon. Did she not?
She said, I don't want to misquote the record, but I don't think she said at the time I knew, but when I examined her at the motion for new trial, she was very honest and said, yes, I was. Those are my dispositions. I got sent to prison when I violated. So I think the same inference that you knew you had a felony after you get revoked for your first offender is apparent in this case as well. I want to cite a case called Humphreys versus the state. This is in my brief, several points, but it's 287 Georgia 63. The relevant language is 69 through 71, Division 4. This is Justice Namias writing for the majority in the case, and in his discussion of juror misconduct like this is a 2010 case, and he's still citing the common law remedy cases. So I don't think it's as clear as the state has argued that, that the upright men language of the Constitution is no longer included in what inviolate means under paragraph 11A. Conversely, I think that the Humphreys citation to these old common law cases shows that these are still good law, and that Georgia, statutorily or otherwise, has retained this as the remedy for this problem. And then the last point I'd like to make is, when we talk about juror bias, right, a big part of the state's argument is that the remedy here needs to hinge on whether the juror was biased. The court needs to draw a distinction between cases where the newly discovered evidence about the juror showed that they were excusable for cause versus whether they would have been a good judgment for a peremptory challenge. All of those cases that have been cited, the Green case, I think the Sears case, they deal with they talk about this standard in the context of juror bias, but none of those jurors were found to be ineligible or statutorily, cannot serve. It was still a judgment call for those lawyers whether they would have, and the complaint there was, had I known this information, I would have used a peremptory challenge. That's not the same as what we're dealing with here. So I think those cases are distinguishable, and I think we have a clear reversible error in this case.
Thank you.
Thank you.
So,
Thank you, Your Honor, for having us this morning. May it please the court.
No, it doesn't. Okay. I'm not going to read this in full. I can another time if you are interested. But, you'll see here. The defendant won. The trial was vacated, and all three will be getting new trials. I think only Mills has gotten his so far, but the other two will as well. Hey, Kat. Thank you for that, both Kat and Factual. What was I saying? Yeah. The court was not pleased. So yeah, I think that's all I have for today. That's all the hatred I have in my heart at the moment. That's not true. It's much of the hatred that I have in my heart at the moment. Can you link the video on the death penalty case you're talking about? Oh, yeah, sure. Hold on. That's a whole stream, though. I need to do a shorter one because I actually care about that topic and want people to watch that video or a video. Let me see here. Let's play it up for you. Here it is. I had no idea it was this long. I think only like the first half of it is. Can you link in a comment? Yeah. Oh, you beat me to it. Are there any grant opportunities? Excellent candidate to pursue funding. I started to look at it, but I haven't. Remember to like this stream. That's a good point. Like, and subscribe, everybody. Someday I'll remember. But yeah, I think I'm gonna do a more concise video on that. But yeah, I appreciate everybody coming. I think I've been going for a while now. 150. Oh my goodness, yeah, I have. Yeah, okay. I might do another stream soon. I'm starting to get the hang of this, except for like the first 2 minutes. But yeah. I think I'm going to call it a night, and I think I'm going to watch some more stuff myself. What if that done say? I thought the state's lawyer said one was denied. Oh yeah, that was a motion for a new trial though. This either they'll be able to file a habeas, or the state will just concede and they'll file a motion for reconsideration and stipulate to a new trial. But he'll get to a new trial. I can't remember whether that was White or I think that was Carter that got denied already. The Innocence Project, yeah, it is. The Innocence Project is actually a bunch of different organizations too. A lot of people don't understand that. Forgetful like Kevin. All right, everybody. I'm going to call it a night. And yeah, thanks for coming in. And I'll see you soon. I'll let you guys know what topic I decide to do next. But yeah, thanks again. And have a good one.